Imagine this. Your employee walks out the door with your confidential client list, and then it uses it to launch a competing business. You're furious. You want justice. So you call your lawyer and you say, "Can I sue them?" And what do most people say? "You can't sue an employee. They're protected. It's too expensive. It's not worth it." Let me tell you something. They're wrong. I'm Santiago Cueto, a board-certified international business lawyer and best-selling author based right here in Florida, and I've spent nearly 3 decades protecting businesses like yours from internal threats, employee misconduct, and post-employment sabotage. Today, I'm here to bust the top 5 myths that Florida business owners believe about suing employees and show you exactly what the law actually allows. Here's myth number 1. You can't sue an employee after they quit. Wrong. Quitters don't give an employee a get-out-of-jail-free card. In Florida, if an employee steals trade secrets, violates a non-compete, or damages your business, even after they resign, you absolutely can bring a civil lawsuit. In fact, the Florida Uniform Trade Secrets Act allows you to seek injunctive relief and damages for misappropriation, even punitive damages and attorney's fees in some cases. Quitting doesn't erase liability, it can actually trigger it. Here's myth number 2. You need a written employment contract to sue an employee. False. While contracts make things easier, they're not required for every legal claim. Let's say an employee defames your business on social media or accesses your systems without authorizations. That's not a breach of contract. It's a tort or possibly even a cybercrime. Florida law gives employers several ways to pursue rogue employees under common law theories. Conversion, defamation, fraud, tortious interference, the list goes on. Contracts help, but the absence of one doesn't leave you powerless. Here's myth number 3. Non-competes are unenforceable in Florida. I hear this one all the time. People throw out buzzwords like right to work state or employee freedom, as that means non-competes are dead in the water. Here's the truth. Florida favors the enforcement of reasonable non-compete agreements. If your agreement protects a legitimate business interest, like trade secrets, client relationships, or specialized training, and the time and geographic scope are reasonable, Florida courts will absolutely enforce it. In fact, Florida has some of the strongest pro-employer non-compete statutes in the country. So if an employee violates one, yes, absolutely you can sue, and yes, you can win. Here's myth number 4. Suing an employee makes you look like the bad guy. This is more emotional than legal, but it stops a lot of businesses from acting. Here's the reality. If you don't enforce your rights, you invite more misconduct. Word spreads fast in a company. If one employee gets away with theft or sabotage, others may test your boundaries too. Smart enforcement isn't about being aggressive. It's about protecting your reputation, your clients, and your culture. Litigation sends a message. This business doesn't tolerate disloyalty, and it defends what it built. Here's myth number 5. It's too expensive to sue an employee. Litigation isn't cheap, but here's what's really expensive: unchecked damage to your business. Florida law allows you to recover not only your actual damages, but in some cases, attorney's fees, especially in contract disputes and trade secret cases. And if you act fast, through emergency injunctions, you can stop the bleeding before the damage snowballs. Plus, lawsuits can lead to settlements. Many never reach trial. What matters is showing you're serious and building leverage. So no, it's not always too expensive. So sometimes it's the most cost-effective move you can actually make. So let's recap. Yes, you can sue former employees. No, you don't always need a contract. Non-competes are enforceable. Enforcement protects, not destroys your reputation. And lawsuits aren't just a cost, they're a form of protection. Don't let myths hold your business hostage. The law is a tool, and when used correctly, it's one of the most powerful tools a Florida business owner has. If you've been burned by an employee or want to bulletproof your business against future threats, reach out. And don't forget to like, subscribe, and comment below with your questions. I post weekly videos on how to protect your business and win in the courtroom before you ever step foot inside it. See you on the next one.